Hello, 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 and welcome to the grand finale of the journey into UCC 3, Part 6. I do have the ultimate grand finale outfit on for you guys. I've been planning this. This is the original mankini. I know all the ladies out there would desperately love me to stand up. If I stand up, my YouTube account will be permanently banned off the face of the earth. So I will not be standing up during this. So all the ladies out there, you can go ahead and just imagine whatever you want. And then I went ahead and went even a step farther for you guys because this is the grand finale. And I wore a special matching hat that I really enjoyed. Let me get a Four Loko, a boner pill, and $6 on pump 2. Absolutely critical communication on my hat. I hope you guys have been enjoying the UCC 3 series as much as I have. It's been huge to the point where it's been such an epic journey. It's been such a crazy thing. I have so many different. So I have already sent out the novation, which is the first letter, and then also the second letter for the Small Business Administration for the COVID horseshit, and then also for the DMV for tricking me into a driver's license and issuing illegal security known as a certificate of title for a motorcycle I never gave them the right to, which is a federal trademark violation, as well as a whole bunch of other things. So we've got a lot of crazy things happening. This is the new series of 2.0 litigation. So it's going to be a novation and then a couple of letters, and then there's going to be something called a certified complaint, and then it's going to be structured in a whole different way. It's going to be the same basic overall structure as the other lawsuits, but it's a whole new thing, and there's going to be some really crazy things that I'm really excited about showing you guys on how that's all going to work. Once the first case is filed, and I'm going to be serving the documents for the summons, I'll probably do a video breaking down the entire process, A to Z, so you guys can see every single line, every single word, every single thing. And I think that'll be really helpful. I haven't done that before because I was kind of like not too sure how I wanted to structure things, and I wasn't too sure how this all worked. And I've been kind of just walking through the dark. But this 2.0 is my first real like brainchild, and I'm pretty excited about how it's going to all go down. So I'm feeling comfortable breaking the whole thing down for you guys. That'll probably be in the next few weeks or whatever. And then I also have another litigation show that I did with Andy Kaufman, Dr. Kaufman, recently, more advanced than the last one we had done. That's going to be litigation mini course video number 3. And then I also have a show booked with Joey Kimbrough, my right-hand man, and we're going to be going through one of his cases that he actually won a few tens of thousands of dollars on. And we're going to be going over how he won it, what he did, what he could have done better, and we're going to start to do litigation critique videos to start giving you more ideas as to how this all works and give you more confidence getting started in litigation as a pro se litigant. Okay, guys. So with that said, let's get rolling on UCC Article 3, Part 6. So we've got 3-601, discharge and effect of discharge. The obligation of a party to pay the instrument is discharged as stated in this article or by an act or agreement with the party which would discharge an obligation to pay money under a simple contract. Discharge of the obligation of a party is not effective against a person acquiring rights of a holder in due course of the instrument without notice of the discharge. This seems important. Let's try to sort this out. Let's see here. The obligation of a party to pay the instrument is discharged as stated in this article or by an act or agreement with the party which would discharge an obligation. So I guess, okay, this is interesting. I think I'm starting to see this. So just like we saw earlier, I forget where we saw it. Let's see here. There was one where we saw that like a negotiable instrument being exchanged acts as though it is money. Let me see if I can find that real quick. meaning it's not money, but it acts as though it is money. I don't know if you remember that one. I vaguely remember that. I know it's here. Let's go through. I'm gonna do part 4 is kind of big. Damn. I remember there being something on. Let's see here. We're gonna hit these real quick and see, and if not, then we're gonna move on. Yeah, I remember there being somewhere where it was like the negotiable instruments act as though they are money, but they aren't money, kind of a thing. So I think what this is saying is that if there was an obligation to pay money under a simple contract, if the contract said, I will pay this amount of money, then the obligation is discharged. So I guess this line right here almost is the explanation for the Federal Reserve note where it says this is legal tender for all debts, public or private. What's the wording on that? Let's see here. This note is legal tender for all debts, public and private. That little note kind of reminds me of this. If someone said they were going to pay money and they give an instrument, a negotiable instrument such as a Federal Reserve note, it discharges the obligation to pay money. So this is interesting. This could definitely be very useful for your litigation, banking, etc. You're not talking about money at any point in time, which I think it's better to just be clear. But if for some reason you weren't clear or they weren't clear on if it's money or negotiable instruments, because they're never talking about money, then this section would be the usable section for that particular situation. That's what I get from this. Discharge of the obligation of a party is not effective against a person acquiring rights of a holder in due course of the instrument without notice of the discharge. Notice of the obligation of a party is not effective against a person acquiring rights of a holder in due course of the instrument without notice of the discharge. If you become the holder, then, yeah, I'm not sure. It wouldn't be a discharge unless somebody gave you notice of the discharge. I'm not totally sure on that one. Discharge of the obligation of a party is not effective against a person acquiring rights of a holder in due course of the instrument. So if someone becomes a holder, then discharge wouldn't be effective against that person. I guess because the holder is the one that would approve the discharge? I don't know. Without notice of the discharge. I'm not totally sure on this one. Not totally sure on this one, and I'm not sure it's all that important. It seems like medium importance to me. Discharge of the obligation of a party is not effective against a person acquiring rights of a holder in due course of the instrument without notice of the discharge. Discharge of the obligation of a party is not effective against a person acquiring rights of a holder in due course of the instrument without notice of the discharge. I'm not totally sure on this one, guys. I do apologize. Not too sure on that one. Let's go to the next one here. Payment. Okay. Oh, geez. 3-602. Subject to Section B, an instrument is paid to the extent payment is made, 1, by or on behalf of a party obligated to pay the instrument, and 2, to the person entitled to enforce the instrument. So from the person who's supposed to pay it to the person who holds the note or whatever. That's pretty simple. To the extent of the payment, the obligation of the party obligated to pay the instrument is discharged, even though the payment is made with knowledge of a claim to the instrument under 3-306 by another person. The obligation of the party obligated to pay the instrument is discharged, even though payment is made with knowledge of a claim to the instrument under... Not too sure on that one. It's discharged even though payment is made with knowledge of a claim to the instrument. So even if somebody else claims the instrument, it's still a payment. Something like that. Like if there's 3 parties, something like that. I'm not 100% sure on that one. B, subject to subsection E, a note is paid to the extent payment is made by or on behalf of a party obligated to pay the note to a person that formerly was entitled to enforce the note, only if at the time of the payment the party obliged to pay has not received adequate notification that the note has been transferred and that payment is to be made to the transferee. Oof. So if somebody previously was entitled to enforce the note and there was a payment made, it still applies if the party obligated to pay has not received adequate notification that the note has been transferred. So if the note's transferred and the new person didn't let the old guy who was supposed to pay know, then that payment is to be made to the transferee. Okay, so the new person who holds the note is the person it's supposed to be transferred to. Whoever holds the note. That makes sense. If the mortgage is sold to another mortgage company, then if you pay the old mortgage company, they'll send that payment to the new one, basically. A notification is adequate only if it is signed by the transferor or the transferee, reasonably identifies the transferred note, and provides an address at which payments subsequently can be made. Upon request, the transferee shall seasonably furnish reasonable proof that the note has been transferred. Unless the transferee complies with the request, a payment to the person that was entitled to enforce a note is effective for purposes of subsection C. So if they don't tell you that it's been transferred and you pay the old guy, then it's still a payment and it still applies. Pretty simple. Common sense. Subject to subsection E, to the extent of a payment under subsections A and B, the obligation of the party obligated to pay the instrument is discharged. Now, I've heard some stuff recently, real quick on this. I've heard some stuff recently about people sending in notes and people sending in stuff, and then they run off and they sell the note to another company real quick under your nose. This is what you can use in that situation, by the way. If they don't tell you it's being sold and you're still making payments, or you made a payment to an old holder or anything like that, if you didn't know or you were never informed, then that payment would automatically transfer to the new holder. So they can't play hot potato with their bar card shuffle horse shit. They can't do that with you with this. This is what you can use for that situation. Okay? Let's see. Subject to subsection E, a transferee or any party that has acquired rights in the instrument directly or indirectly from a transferee, including any party such as a holder in due course, is deemed to have notice of any payment that is made under subsection B after the date that the note is transferred to the transferee, but before the party obligated to pay the note receives adequate notification of the transfer. It's kind of the same thing. Transferees and blah, 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 blah. The obligation of a party to pay the instrument is not discharged under subsection A through D if the claim to an instrument under section 3-306 is enforceable against the party receiving payment, and one, payment payment is made with knowledge by the payor that payment is prohibited by injunction or similar process of court. So if there's a court injunction, you can't do it. Or in the case of an instrument other than a cashier's check, teller's check, or certified check, the party making payment accepted from the person having a claim to the instrument. I'm not too sure on that. Let's go to part 2 here. The person making payment knows that the instrument is a stolen instrument. Okay, if it's stolen, okay. As used in this section, signed with respect to a record that is not in writing includes the attachment to or logical association with the record of an electronic symbol, sound, or process to with the record with the present intent to adopt or accept the record. Okay. So anything that shows that you've accepted this thing can be considered signed if it's not in writing, I guess. Tender of payment. This is our favorite one. This is one of the most powerful things in all of UCC 3, 3-603. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, the effect of tender is governed by principles of law applicable to tender of payment under a simple contract. That's just fine. This is the big boy right here, Section B. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender. Okay, I had to pause the video for just a moment. I am back. Let me get back to where I was at. If tender of payment of an obligation to pay an instrument is made, this is the big boy right here. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender of the obligation of an endorser or accommodation party having a right of recourse with respect to the obligation to which the tender relates. So this right here, if there was like a top 3 or top 4 most important things you have to know in all this information, this would be like top 3 or 4, I think. So let's break this down. So tender means unconditional offer. Payment means performance, okay? Endorsement is a payment, okay? Of an obligation to pay an instrument is made to the person entitled to enforce, which is the person who sent it to you. So utility company sends you a bill of exchange. They're the person entitled to enforce. And you tender a payment, which means you tender back the bill of exchange with an endorsement on it of an obligation to pay an instrument. The endorsement and the tender, if the instrument and the tender is refused, there is discharge to the extent of the amount of the tender. So if the bill of exchange was for $77, if it was an unconditional order to pay for $77, then you would be entitled to a discharge of $77 of the obligation of an endorser or accommodation party having, so you're the endorser, having a right of recourse with respect to the obligation to which the tender relates, right? So you have a right of recourse. You have a right to sue them or for damages or whatever if, as the endorser. Okay? C, if tender of payment of an amount due on an instrument is made to a person entitled to enforce the instrument, the obligation of the obligor to pay interest after the due date of the amount tendered is discharged. So you don't pay interest. You don't pay interest after you pay. Okay, duh. If presentment is required with respect to an instrument and the obligor is able and ready to pay on the due date of every place of payment stated in the instrument, if presentment is required with respect to an instrument, if payment is required with respect to an instrument and the obligor is able and ready to pay on the due date at every place of payment stated in the instrument. What? If presentment is required with respect to an instrument, and the obligor is able and ready to pay on the due date at every place of payment stated in the instrument. The obligor is deemed to have made tender of payment on the due date to the person entitled to enforce. Holy shit! you guys seeing this one? This is huge. So let's review presentment real quick. A demand made by or on behalf of a person entitled to enforce an instrument or to pay the instrument made to the drawee or a party obligated to pay the instrument in the case of a note or accepted draft payable at a bank to the bank, or to accept a draft made to the drawee means a demand made by or on behalf of the person entitled to enforce to pay the instrument made to the drawee or a party obligated to pay the instrument. What is the obligor? Let's see. A person who is bound by another by contract or legal procedure. A debtor. Okay, the obligor is the debtor. Okay, good. So if presentment is required with respect to an instrument, and the obligor is able and ready to pay on the due date at every place of payment stated in the instrument, which means performance. So perform in every way in which you're supposed to perform in the instrument. The debtor is deemed to have made tender of payment on the due date to the person entitled to enforce the instrument. Oh, Jesus, this is unbelievable. So this goes with subsection B. If you're ready and able and you've made it a point that you're ready to go on the due date, then it's as if you made a tender of payment on the due date. That's pretty cool. That's almost like, even if you didn't send anything, just being willing to perform. Like, for example, if I was in a court case and they're like, you know, blah, 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 sanctions, or they say some stupid shit, I'd be like, oh, dude, I'll perform right now. You give me an unconditional order to pay, I'll perform literally right now. I got a pen on me right now. If presentment is required with respect to an instrument and the obligor is able and ready to pay on the due date at every place of payment stated on the instrument, the obligor is deemed to have made tender of payment on the due date to the person. Yeah, it's good. That's pretty wild. I mean, it's cool. It goes with section B, but it shows even just intent alone, even just saying it or even just communicating it is enough to be considered tender of payment. Interesting. Well, that's pretty interesting. 3-604, discharge by cancellation or renunciation. A person entitled to enforce an instrument with or without consideration may discharge the obligation of a party to pay the instrument, 1, by an intentional voluntary act, such as surrender of the instrument to the party, destruction, mutilation, or cancellation of the instrument, cancellation or striking out of the party's signature, or any addition of words to the instrument indicating discharge. So they can just discharge it just by whatever, just by saying it, basically. Number 2, by agreeing not to sue or otherwise renouncing rights against the party by a signed record. Okay. Cancellation or striking out of an endorsement pursuant to subsection A does not affect the status and rights of a party derived from the endorsement. Okay. That seems pretty self-explanatory. I'm not too sure exactly how that would work, but that's pretty self-explanatory. As used in this section, signed with respect to a record that is not a writing includes the attachment to or logical association with the record of... This is the same wording we saw in the last one. 602, I think it was. Sound or process that shows that it was accepted. I assume this is probably talking about acquiescence. Huh. This is probably talking about acquiescence. So like, like when you don't respond to something, it can be considered like a process, which is, I guess, is considered signed. The present intent to adopt or accept the record. Well, accept means it means delivery. So if it was delivered and they can prove it. Huh. As used in this section, signed with respect to a record that is not a writing includes the attachment to or logical association with the record of an electronic symbol, sound, or process to or with the record with the present intent to adopt or accept the record. Okay. I see acquiescence in this. I see the idea that it was delivered and there was no actual signature. There are other things such as processes, sounds, and electronic symbols that mean basically signed. If it's not written or there's not a written record of your signature, this is kind of how they do it, I guess. I assume that's kind of what this is. It's kind of interesting. Discharge of endorsers and accommodation parties. Wait, what? That's interesting. So the name on the first page, discharge of endorsers and accommodation parties, changed. Discharge of secondary obligors. I don't know what that means. Interesting. Okay, well, let's go through this. If a person entitled to enforce an instrument releases the obligation of a principal obligor in whole or in part, and another party to the instrument is a secondary obligor with respect to the obligation of that principal obligor, releases the obligation of a principal obligor in whole or in part, and another party to the instrument is a secondary obligor. The following rules apply. Releases the obligation of a principal obligor. So the person entitled to enforce has released the primary obligor, but there's a secondary debtor. Same word, debtor. With respect to the obligation. The following rules apply. So there's a cosigner, and then they say, fuck the first guy, and they go after the second guy. Any obligations of the principal debtor to the secondary debtor with respect to any previous payment by the secondary debtor are not affected, unless the terms of the release preserve the secondary debtor's recourse. The principal debtor is discharged to the extent of the release from any other duties to the secondary. It's interesting. What's the terms of the release preserve the secondary debtor's recourse? The principal debtor is discharged to the extent of the release from any other duties to the secondary debtor. So I guess the secondary debtor does not take on the debts of the original debtor, something like that. That's what I get from this. It's kind of interesting. I'm not too sure exactly how that would work in a real life example, but this does not seem like it's a very important section for what we're trying to do. 2, unless the terms of the release provide that the person entitled to enforce the instrument retains the right to enforce the instrument against the secondary debtor. The secondary debtor is discharged to the same extent as the principal debtor from any unperformed portion of its obligation on the instrument. So unless there's some previous contract, then the second guy is released when the first guy is released, something like that. If the instrument is a check and the obligation of the secondary debtor is based on an endorsement of the check, the second debtor is discharged without regard to the language or circumstances of the discharge or the release. If the secondary debtor is not discharged under paragraph 2, the secondary debtor is discharged to the extent of the value of the consideration for the release and to the extent that the release would otherwise cause the second. I mean, I don't think this is all that important here, guys. I mean, a person entitled to enforce an instrument grants a principal debtor an extension of the time at which blah, 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 any obligations of the principal debtor or the secondary debtor with respect to any previous payments by the blah, 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 blah. Secondary debtor is discharged to the extent that the extension would otherwise cause the secondary obligor a loss. I just don't see any of this being very important for what we're trying to do. To the extent that the secondary obligor is not discharged under paragraph 2, the secondary obligor may perform its obligations to a person entitled to enforce the instrument as if the time for payment had not been extended, or unless the terms of the extension provide that the person entitled to enforce the instrument retains the right to enforce the instrument against the secondary obligor as if the time for payment had not been. Yeah, it's just not. I'm not seeing the importance here. If a person entitled to enforce the instrument agrees with or without consideration to the modification of the obligation of a principal obligor other than a complete or partial release or an extension of the due date, and other party to the instrument is a secondary obligor with respect to the obligation of the principal. Yeah, I'm just not going to read this. I don't see any of this being. Let's just go over this real quick. Let's just scan over this. Yeah, I don't know. I don't know, and I don't care. I don't see this as being important. Yeah. Yeah, I just don't think that's very important. And I'm not really going to get into it too much. Okay, guys. That's it. This one's short. I've got a lot going on, so I just wanted to get this done. It's been like 12 days since the last one, part 5. So that's it. That's UCC Article 3. The key places that you want to make sure, if we were to just do a quick overview, the most important ones, in my opinion, are, let's see, this one, and this one, and here's our rescission for if we want to pull it back. Here's our special endorsement. That's super important. Negotiation is really important. Person entitled to enforce is pretty important. Value and consideration is really important. Holder in due course is really important. Signature is important. You know, I'd say maybe half these are pretty important, maybe 40% of them. The rest are kind of like, you know, some level of importance. This one's super important. We're going to use this one a lot. We started using it already on case 2. This article applies to negotiable instrument. It does not apply on money. So they're talking about money. You just jump all over them. Just rip them apart. Objection. I kept telling one of my clients we did a long conference call today because I was training him, getting ready for a hearing tomorrow. And if they bring up money, it's just instantaneous. Like, I must be in the wrong room. I must be in the wrong court case. I must have taken a wrong turn. There must be a guy who has looks like the same name as mine, but this must be the wrong case because I didn't come here to talk about this thing called money. And this thing called money has absolutely nothing to do with any of the concerns at all whatsoever with this court case. The two biggest words that you can just jump all over and just scream to high heaven is the word loan. There is no loan. They're all a currency exchange. They are not a loaning or a lender. They are a currency exchange. And you'll see that in a lot of my cases if you're on Pacer, and if you're not, you're stupid. You should be on Pacer looking at all the stuff that we're filing into the dockets. You'll see all the stuff that we're doing, all the ideas, everything you could ever dream of. All your questions will get answered if you just read the fucking dockets. Please, for the love of God, read the fucking dockets. Yes, it's a lot to read. Tremendous amounts. But if you don't read the docket, then just don't even try. There's no point. If you can't even read the goddamn thing, you're sure as hell never going to be able to write it and get through this. So you might as well just give up now while you're behind, okay? All the definitions are really important, obviously. What is a negotiable instrument? 3-104, very, very important, especially this subsection A, right? What is it? Unconditional versus conditional. Very, very important. I made this mistake on case 1, which is why case 1 was dismissed. This is why. And I learned from that. You know, I had read this a million times beforehand, but then it finally made more sense to me. Payable to the bearer does not say to payee, which means a blank endorsement. This is important. Special endorsement states the payee. Blank does not. Very simple. Payable to bearer is a blank endorsement. And negotiation. You know, what is negotiation? Transfer of possession of an instrument by a person other than the issuer to a person who thereby becomes holder. And I know there's probably some thoughts of, well, I'm the issuer, aren't I? Well, you know, there's two parties. There's you, and then there's the all caps name. So I don't really know exactly how that would work. But I'll for sure as hell fight it to the end of the earth because that doesn't make any sense to me. So yeah. Okay, guys, I'll be making some more videos at some point. Don't know when. I'll probably be building the course 2.0 version slowly but surely. I'll be making the video with Joey Kimbrough. We're going to be breaking down one of his cases. We're probably going to break down Wesley Snipes' case. It's got 602 filings into the docket. So we'll probably just kind of scan through it. We're obviously not going to go through 602 filings. That's going to be ridiculous. A lot of it's probably horseshit anyways. Bar card shuffles and irrelevant billables and all sorts of good stuff in there. Point number 3, you know, I'm going to be building out case number 2, 2.0 with the litigation. When that's done, I will be doing a full breakdown video on how all that works. And for everyone wondering when the course version 2.0 is going to come out, I have no idea. Probably this year at some point in time. No idea. Don't ask me. If you ask me, you'll be either ignored or blocked. And then, yeah, there's a bunch of other cool stuff. I hope you guys are checking out the Williams & Williams law firm website. I've added a lot of cool new stuff to the questions and answers page, as well as the about page. There's a link on the about page for a state case where I changed my name to my registered trademark, link to that, link to a brand new power of attorney that I just did to replace the old power of attorney I had between myself and the ens legis. There's a link that you can see the new power of attorney. Just happened a handful of days ago. I just did a new power of attorney with my ens legis. You can pull that up. Tons of new stuff on the questions and answers page for Williams & Williams. There's a whole section now on the 14th Amendment. There's a whole section now on different terms that we are designing specifically to combat the bar cards and how they make terms for us. Terms like the bar card shuffle, irrelevant billables. There'll be more and more and more terms that will be added to that list as we go forward. The 14th Amendment stuff is really cool. I added that same 14th Amendment section got added also on the Nation of the Amnesty Coalition page. I'm trying to think of what else is new. There's so many new things. Always something new happening. I do recommend every 3 or 4 months, probably you should go on to all the different pages and check out all the different pages. Again, if you want to see, there's always changes happening either on Williams & Williams or the questions and answers pages, or there's just a lot happening. So if you guys want to check that out every 3 or 4 months, I think you should. I hope you guys have gotten as much out of this particular UCC 3 series as I have. This is all the information you will need to know to build a great lawsuit, in my opinion, and to absolutely crush it in the court system. If you take all this information and combine this information with litigation procedure, like the actual procedures of litigation, like filing a complaint and counter complaints and answers and discovery and motions. And if you start to study all that stuff, I am making some videos on that, but there's also the jurisdictionary course, howtowinincourt.com, which is a great course. I've been doing that one myself quite a bit, and then I'll be making videos as we go forward as well. And then also reading all the dockets in Pacer, not just on my cases, but any case that might be something along the lines of what you're trying to do. All my cases obviously are negotiable instrument cases. I don't do anything else. So if you're trying to handle other types of cases, CPS or criminal or anything like that, you should be in Pacer looking up as many things as you can to try to get an idea as to how you can build your case for yourself. That's it, guys. I will sign it off for good on this UCC series. So I might do UCC 2 or 4 or 1 or something like that at some point in the future. If anyone thinks that I'm going to be doing UCC 9 anytime soon, you're crazy. UCC 9 is so crazy and difficult. It would just be me wanting to get drunk and smash my head through this table that's in front of me right now the whole time. So I don't know when UCC 9 is going to make more sense to me. As of right now, it doesn't. And anyone who tells me that they do understand UCC 9, I don't believe you at all. Like literally not even in the slightest. Unless you show me massive, like $150 million court cases that you have won using UCC 9. UCC 9 is like my worst nightmare. So I understand little bits and pieces of it. I've looked at it a couple of times, but it's just like way too fucking crazy and complicated. We will get there slowly but surely. So yeah, there you go, guys. Signing off. See you later.